Then Article 3, we move into the judicial power. So Section 2 of Article 3 contains, again, the familiar statement and limitation that the judicial, what the scope of the judicial power is. So the judicial power extends to any cases in law and equity arising under the Constitution, the laws of the United States, treaties, and a variety of other cases in which there is some kind of justiciable controversy. Notice that this clause doesn't indicate that the judiciary has any authority specifically to adjudicate the question of whether the United States should go to war. So there is one place in which the Constitution does give the judiciary some specific responsibilities with respect to things that can be considered related to the war powers, and that is trying cases involving treason. So those cases have to be adjudicated judicially, but we can see that there doesn't seem to be any other circumstance in which a war powers issue is adjudicated by the judiciary. Now, of course, we know now through a history of constitutional law and adjudication that the judiciary is seen to have the power of judicial review. So it could be that the judiciary could look at a specific congressional enactment and decide whether it is consistent with the separation of powers or not. And in fact, the Supreme Court has, the federal courts have done that on numerous occasions. But the Constitution doesn't give the judiciary any role in adjudicating whether the United States should go to war or how the United States is prosecuting wars or things along those lines. So, think about a few ambiguities in the constitutional text itself. What is war? Does the war powers include small-scale actions that might involve the military? Does it include emergency actions that might involve the military? It's not entirely clear what war means under the Constitution. What does it mean to declare a war? For Congress to declare a war, does it mean to recognize that some existing actions undertaken by the legislature are war, or does it mean to actually initiate war? How can the military be used, if at all, short of creating a state of war? Can the military be flown in to a crisis area to secure order while medical supplies are being distributed? Not specified in the war powers provision of the Constitution. Can Congress use its appropriation power to limit the executive power over the armed forces? For example, by putting a condition in an appropriations bill that says we only will give this appropriation if the president commits our forces in X way or doesn't commit our forces in X way. Well, some of these questions were attempted to be answered through the War Powers Resolution. So let's talk a little bit about that resolution, what it says, and what some of its limits are. And as we'll see when we look at some case law, very likely in its current form, if actually applied, it would be held to be unconstitutional. So the War Powers Resolution was adopted in response to the Vietnam War, and there were obviously a lot of issues, public issues, with respect to how the Vietnam War was prosecuted and why it was being prosecuted. There were a lot of issues involving secrecy and potential abuses of executive authority. So Congress adopts the War Powers Resolution in response to that. Note that Congress adopts the War Powers Resolution over President Nixon's veto. So President Nixon issues a veto statement saying that he believes that the War Powers Resolution is unconstitutional because it gives Congress too much authority over the executive function with respect to the war power, but Congress overrides that veto. And the purpose of it, as you read it, is to seek to prevent the president alone or the president and Congress acting together from instituting war covertly or by mistake, inadvertently, by some kind of escalation of hostility. The key provisions of the War Powers Act, as you read through it, you can see Section 2, the statement of policy really suggests that it's intending to implement and to put kind of a framework around the constitutional war powers provisions. And the way it tries to do that is through a process of consultation, reporting, and then response by Congress. So consultation requirement says that if hostilities are imminent, the president has to consult with Congress about that. The reporting requirement says that within 48 hours of when troops are introduced into hostilities, the president needs to give a report to Congress. And you can see some language about what that means in the statute. And then a really key piece of it is that at least once every 6 months, the president has to continue to report to Congress about the status and the ongoing status of those hostilities. So now, as this reporting is being done to Congress, then Congress has some powers under the statute to act or not act. So within 60 days after a report is submitted, pursuant to the statute, that's a trigger pursuant to the statute, the president is required to terminate that military action unless Congress either has formally declared war or issued a specific authorization for the use of force, or Congress has acted to extend the 60-day period, or Congress is physically unable to meet because of the war, because Congress is under threat. So notice that this gives Congress an ability to act in response to what the president has done, and effectively gives Congress what's called a legislative veto over what the president has done with respect to committing those troops. And that is a really controversial piece of the War Powers Resolution. In fact, I gave you some material to read from the National War Powers Commission, which you can see is led by some very influential and powerful people in the national security field. That report notes that the War Powers Resolution has been widely criticized as possibly unconstitutional because of the way it gives Congress this legislative veto. And this is important, I want you to notice this, no president in 35 years has ever filed a report pursuant to those triggering provisions. Now, we all know over the past 35 years that the U.S. has been involved in numerous military actions, including things that we call a war. I mean, we call it the Gulf War. So how has this been gotten around? Well, presidents have issued reports to Congress, but they have indicated that the reports are consistent with the War Powers Resolution, in significant part in an effort to try to not trigger it by saying that they're issuing the report pursuant to the War Powers Resolution. The National War Powers Commission report also proposes an alternate framework. I don't necessarily need you to know what that framework is, but just be aware that there are other ideas floating around for how you could have some accountability between the executive and Congress without having the possible constitutional problem of the legislative veto.